Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing property and real estate planning, so sort of getting one's ducks in a row, if you will, with respect to property and real estate when living in Thailand when married to a Thai national. I thought about making this after a comment on another video we did where we were talking about property rights or lack thereof for foreign spouses of Thai nationals. There was a comment on a video, and I thought I'd go ahead and quote it, quoting directly. Ben, I think this video deserves a follow-up on the basics of how a foreign spouse can mitigate around this, i.e. my understanding is the 30-year lease on actual property. Question mark, am I wrong? Basically what's being asked here is, okay, understanding that foreign nationals are not entitled to have rights to land, specifically real estate land, here in Thailand, not even if they're married to a Thai national, and we've gone into great detail in other videos on that. The question arising in this video from that comment is, for example, what about 30-year leases for the foreign spouse of a Thai national? Yeah, that's certainly a possibility. We've talked about that a lot on this channel in the past. It is possible for a foreign national to secure a long-term lease on property here in Thailand, and the property owner could be one's spouse. There also may be other methods of dealing with that. Bifurcation of title, as we've discussed in other videos, where you essentially bifurcate the title to the housing structure from the actual land itself. Other things like possibly, in certain circumstances, mortgages can be utilized, or even what are called usufructs, which, in the way that they're kind of used in the foreign community here in Thailand, I liken them to what are called life estates in American jurisprudence with respect to real estate. So it's basically usage of property in one's lifetime, and then when one passes away, that right extinguishes and it reverts back to the underlying landlord. Again, these are all circumstances which are, it's circumstantially dependent what's going to be best. But yes, there are methodologies for lack of a better term, mitigating or structuring a marital estate in such a way that the foreign spouse is not entirely exposed when it comes to usage of the property, ongoing, in the event of separation or in the event of possibly divorce, dissolution of marriage. Again, it's all going to be factually specific, factually dependent. So those who are interested in this topic, probably a good idea to go ahead and contact a legal professional, gain some insight and guidance as to what works best under your circumstances.